Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there and welcome back once again to Ask a Lawyer here on CP24. My name is John Scholes, your host, and joining me very shortly will be Chris Justice, you bet, from Samfiru Tumarkin LLP, EmploymentLawyer.ca. To reach Chris anytime, I always give you the contact information off the top, don't we? 1-855-821-5900. Ask at EmploymentLawyer.ca through email, which we'll get to a few of those a little later on in the show. The main topic in just a bit is going to be, can my employer ... do these things? I'll throw those at Chris and he'll answer them. Very common questions. In fact, we answer the questions that you throw us each week. Way to do that is that email. We'll get to a bunch of our phone calls. We host radio shows across the country, and more specifically right here in the GTA, Sundays, 1 p.m. on our brother station, News Talk 1010. An opportunity always for you to call into that show, and who knows, your phone call may end up here. So we'll get to all that in just a bit. But Chris, we always start off with the week that was. What's going on your end, pal?
Yeah, so first of all, again, very happy to be here. As we know, employment law affects our lives on a daily basis. Very important, whether it's wondering what a contract says and what it means, whether you're having an issue with your boss, whether you've been packaged out, you've been given a severance package and you're wondering whether it's actually sufficient. Whatever it is, it affects us, as I say, in all aspects of our working lives. And so that's why it's so important for people to seek legal advice, to get that advice from a lawyer, from an experienced employment lawyer, to make sure that at least moving forward, you know what your next best steps are going to be. But today, I wanted to talk about a case across my desk that involved an independent contractor, or so he thought. It's a classic scenario where you've got an individual, they're working for a company, they've been let go, and they're being told on their way out that actually you're not an employee of ours, you're not owed any severance, you don't get anything. And this gentleman had come to me and said, Chris, am I dead to rights? What are my options? Because I've got this contract that says I'm an independent contractor. I've got my own business that I invoice through. I remit my own HST. I pay my own taxes. So does that mean that my employer or this company is right, that I'm not actually an employee and I'm not owed anything? And the short answer is oftentimes no. That's not correct. It's actually not you or your employer that decides what you're entitled to or whether or not you're deemed to be an employee or not. It's going to be the law that decides that. And ultimately, even though there may be a few factors that point towards you being, let's say, not a typical employee. So for example, again, you've got your own business, you're taking care of your own taxes. Maybe you've got a contract that even labels you as an independent contractor. Those three factors alone are not going to be enough to determine, are you an employee or not? And oftentimes, you're going to have to go further than that. You're going to have to examine the relationship that you have with the employer in terms of your day-to-day routine. So for example, in this gentleman's case, while he did have his own business and took care of his own taxes, he also had a company email address. He had a company office that was assigned to him. He had a company uniform. He took direction from people in the company, and he was supposed to adhere to company policies. And so it's just an example of when you dig a bit deeper into the scenario, you find out that actually the nuts and bolts of it are more like your employee-employer type relationship and less so about what a contract may be labeling you as. And it's important to know because you're not gonna, understand what your full rights are, first of all, unless you talk to a lawyer. And you could be walking away from a situation like that, putting tens of thousands of dollars to the side when you could have got it had you got that legal advice and had you gone after that severance package that you're owed. So that's what this gentleman did in this case, and it was fortunate that he did that because he was there for a long time, 15 years, and he could be getting upwards of 12, 14, 15, 16 months when he was initially told by his employer that he was owed nothing. So a lot of people find themselves in this situation, what am I? They're calling me one thing, but I'm doing something else. It's not really like that. And again, this is just a prime example of that kind of playing out.
It's funny, the classic case we sometimes look at is the plumber. There's a classic case of an independent contractor. He has his clients, they have their own business, they come and go as they please, They do a job and they move on to the next person. That's an actual independent contractor. Does it make a difference if, say, your friends, your buddies with the owner said, Want to be an independent contractor? Sure, I'll be an independent contractor. I guess that's good enough because we both agree on the terms. That still doesn't make it happen, does it?
Yeah, again, it's another reason why people actually think that they are an independent contractor, because they perceive there to be that mutual agreement between them and the employer. But again, going back to what I said earlier, it's ultimately the law that's going to decide whether you are, not necessarily what you and your employer come to an agreement on. But in your plumber example, yeah, there certainly are cases where you're more of a gun for hire, so to speak, where you're doing a job for one employer, but you've got 15 other employers that you're also doing work for. And in those scenarios, it might be more akin to your independent contractor type scenario. But in a situation that I come across a lot is where you've got this person paying their own taxes with their own business and submitting invoices, but that's the only company they work for. That's the only company they've ever worked for. They rely on that company for money. They're dependent economically on that company. And that's another factor that often points towards them being an employee rather than an independent contractor.
If you're still confused, there's a website to help you out, EmploymentLawyer.ca. There's a section, Am I an Independent Contractor? It'll answer all those questions. There's also a contact button at the top as well, and make that phone call. I did mention the radio show, which we host across the country, and again, right here on News Talk 1010, Sundays at 1 p.m. Myself and sometimes Chris and Leor do that show. Get a bunch of phone calls. We take them, we play them back, we learn something from them, and we'll get to our first phone call from our radio show right now.
I've been employed for a company for 18 years. Today, they tell me due to restructuring, they no longer need me. Director of operations, grew the business, restructuring 18 years, and they offered me 18 weeks.
18 weeks? Wow. How old are you?
48.
Might be a little shy.
Yeah, no,
little shy.
This is a classic scenario. Somebody's been packaged out. They get a severance package. 99% of the time, it's going to be well below what they're actually entitled to. And this is just a classic scenario of someone needing to get advice before they sign off on anything remotely close to that. Because with that many years in, you're going to be owed a heck of a lot more than just 18 weeks. In fact, if we look at the Pocket Employment Lawyer on the board there, it'll show us sort of a breakdown of all the key statistics in this gentleman's case. So you've got his age, you've got his position, obviously a very senior role, been at the company for a very long time, making a good amount of money at that job as well. And so you see down below there at the very bottom what the compensation owed is and how much different it is than the 18 weeks that this gentleman's been afforded. This is probably typically on the much lower end of things in terms of initial offer from an employer. But even if this individual had been given 6 months to a year, we're still talking vastly lower amounts than what he actually could get. So again, all the more reason to be getting legal advice, and you absolutely don't want to sign a full and final release when it comes to your severance package until you get that advice.
Again, that severance calculator, that calculation can be done at PocketEmploymentLawyer.ca, the severance pay calculator. It's free for you to use anytime, so take that out for a spin when you want. Okay, can my employer do this? ... We're going to get to a bunch of those talking points, but first a short break, and we'll come back with lots more Ask a Lawyer here on CP24. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. John Scholes, your host every week, and Chris Justice joining me from EmploymentLawyer.ca. You can always reach out to Chris, reach out and have a conversation. Won't cost you anything just to get some information. 1-855-821-5900, the number. Ask at EmploymentLawyer.ca. Main topic for today, Chris, as mentioned off the top, is can my employer do these things? So the first one is this: can my employer let me go for no good reason? Out you go.
Yeah, absolutely. Your employer doesn't have to have a good reason. It's actually a misconception. A lot of people I speak to think that the employer has to have a solid reason, that it can't simply be a matter of, two people not liking each other. A lot of times people say to me, look, Chris, I'm a top performer. I do my job very well, and yet I've been let go. So that has to be a wrongful dismissal. When that's just not the case. Employers, as I say, can let you go for pretty much any reason they want. Of course, so long as they're not discriminating against you, that's a huge caveat there. But as long as there's nothing like that present, as long as there's no extreme or egregious bad faith or ulterior motives going on, which, for what it's worth, are also often hard to prove at times, employers can let you go. But in doing so, they have to make sure that, of course, you get your full severance package. That's often what we refer to as a wrongful dismissal, is more so not the fact that someone was let go, but on their way out, they were given vastly lower than what they're entitled to, which just before the break, we had looked at with that caller who had gotten 18 weeks. So that's just an example of a wrongful dismissal. But in terms of reasoning, again, employers don't have to have the best reason to let you go.
How about changing your job? Can my employer give me a different job if they choose?
Yeah, so generally that's going to be a big issue. That's going to be considered a constructive dismissal anytime an employer makes significant changes to the terms of your employment that you don't agree to. And an example would be changing the actual job itself. That's going to be, as I say, deemed a constructive dismissal. And you're going to have the ability to essentially tell your employer, hey, look, I don't agree to this position. This is not what I signed up to do. You guys are pushing this on me. I'm ready, willing, and able to do what I did sign up to do, but not this. And so that's going to put the ball in the employer's court. And if they're going to insist on putting that position on your plate, that's going to probably result in a constructive dismissal, which will entitle you to that full severance as though you were let go.
Can my employer stop me from working for a competitor, or is there any wiggle room there? You know what I mean?
So generally speaking, we'll say during the term of someone's employment, you'll often see clauses in a contract that say you got to devote your full-time efforts and attention to our business. So from that context, probably not a good thing to be working for a competitor simultaneously. But when it comes to leaving a company on your way out, oftentimes employers will try and say that following your exit, you can't compete with us in any way. And in Ontario, recently, non-competes were banned altogether. Now, does that apply to older contracts predating the ban? There's a question or an argument to be made there. But even still, historically, courts have hated non-competition agreements. They put a restraint on someone's trade, and they're just simply unacceptable, which is now why they're banned. So your employer won't be able to do it in that sense.
Let me ask you one more. Can my employer force me to come back to work contrary to what my doctor's opinion may be if I'm off?
Yeah, so it is a very problematic situation where a lot of employers will get notes, will get some sort of document from the individual's doctor and just simply not believe it, not buy it, maybe ask for a second opinion, or just disregard it and say that we want you back, and if you don't come back, you know, something may happen bad. And that's a huge issue for employers. That's going to be a breach of human rights, very likely. Your employer cannot force you to go back. It's your doctor, it's the person that you're working with, or the treatment providers you're working with, that are going to decide when you're ready to go back. And your employer is going to have to follow those instructions. They're not going to be able to ask for a diagnosis. They're going to be entitled to a prognosis to get a sense of when you can come back. But as long as you have the support of your doctor to stay off or come back, your employer's generally got to follow that advice and go with that opinion. Again,
more information, contact EmploymentLawyer.ca. Also, how you find a radio station close to you where you can catch our weekly show, including News Talk 1010. We do that Sundays, 1 p.m. Please join us for that. Second phone call from our radio show is coming right now.
I'm an approximately 20-year employee, and my employer decided that he wanted to put us all on contract. Now, I guess for the newer employees, it wasn't so much of an issue, but someone like myself who's been there about 20 years, my question was, would that affect me in terms of seniority should something happen in regards to severance? From what I understand in the contract is that we are being rehired by the company.
Yeah, that's a big bowl of wrong right there. That's not going to happen.
Yeah, always raises alarm bells when you've got an employee during the course of their employment get handed a contract. You know, a lot of times the employer is going to say, oh, it's just a matter of signing, it's just some paperwork, don't worry about it, we're confirming what we already know. And lo and behold, there's a little section in there that says, if we let you go, we're going to give you the bare minimums. Or there's some other section that says, we can change your job around. Or you never know what the fine print's going to say. And as much as you might think, oh, it's just a rubber stamp, let's just get this over with. Yeah, you absolutely don't want to be signing anything like that, especially if you're already well into your tenure. You want to get advice. This is something that comes up a lot in my practice. And yeah, oftentimes people are potentially signing things that will then hurt them extremely so on their way out. You know, they may not have a contract that limits their severance entitlements. They then sign something mid-duration of their employment that does limit their entitlements. And now they're looking at the difference between getting 6 or 7 months, which might be their bare minimum for a 30-year employee, or up to 2 years had they not signed that same agreement. So it's a huge issue. Definitely want to get advice. And yeah, alarm bells should be ringing in your head when something like that gets presented your way.
All right, good stuff. Chris, we'll take a short break. Got that third phone call coming up on the other side of the break, so stick around for that. This is Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back. This is Ask a Lawyer here on CP24. My name is John Scholes. Joining me, Chris Justice from EmploymentLawyer.ca. Reach out to Chris anytime. There's a phone number. You bet, 1-855-821-5900. Email is ask@EmploymentLawyer.ca. And as we mentioned a couple times, we played a couple phone calls already. We do a ton of radio shows actually across the country for about 11 years now, but locally it's here on News Talk 1010 in the GTA, Sundays at 1 p.m. Chris, phone call number 3 is coming at us right now. Let's hear it.
I was let go on Thursday without reason. They just said, we're going to have to let you go. They did give me a release form to sign. They're offering me the standard acts, which is, I think, the 2 weeks. I was doing customer service for 3 years. I am 47 years old.
The old standard 2 weeks, eh?
Yeah, a lot of times people think that when they see a reference to the Employment Standards Act or, I'm getting a payment in line with what I'm owed under legislation, that automatically means I'm being treated in a fair way. When really what's in the legislation is just your bare minimum entitlement, and your potential entitlement is oftentimes way greater than that. You've got a 3-year employee here. She's saying 2 weeks. Definitely dead low, definitely something you're wanting to negotiate. And if we pull up the severance calculator, we can see actually just how much this individual could be looking at. And again, it just goes to show all the more reason why you need to get that legal advice before you sign anything, even if your employer is telling you it's a fair and reasonable package, because you see there the number of months that this individual is owed, even though they may be a relatively short-term service employee doing customer service. So again, it's another scenario where you could be putting tens of thousands of dollars on the table, or leaving it on the table rather, thinking that you're getting what you're deserving of. But no, in this woman's case, it's clear that she's owed a lot more.
Chris, in addition to TV and radio and everything else, does a lot of live streaming you can take part of. That's YouTube and Facebook at stlawyers.ca if you want to contribute to that. And we'll get to our first question from the live stream. Chris on the show tonight says, yesterday my manager said they're laying me off temporarily due to slow business. When I protested, he said that I had no choice but to accept it because I was an hourly worker and he was within his rights. Is that correct?
Yeah, another misconception has to do with the fact that people think employers have the right to put you on a temporary layoff, when in fact there has to be an express agreement or consent given by you as the employee. So a lot of people, especially during COVID times when the pandemic was first hitting, were thinking that, oh, my employer has this right. But no, there's got to be a contract. The contract has to say that I, the employer, have the right to place you on a temporary layoff, because even though the legislation does speak to the possibility of an employer putting you on a layoff, that doesn't tell the whole story. And so anytime someone is placed on a temporary layoff without their consent, without there being an express agreement that would indicate as much, that is also arguably considered a constructive dismissal for which you're owed severance. And the thing about being placed on a temporary layoff is that you're going to want to take action sooner rather than later. I've got a lot of situations where people are put on these layoffs, but they don't contact me until 3, 4, 5, 6 months plus later on. And then the issue becomes, have you implicitly accepted the layoff by virtue of waiting so long? So again, more of a situation where you want to act sooner than later, but a temporary layoff in many scenarios is a constructive dismissal and would give you the option to seek severance as though you had been let go on a without cause basis.
All right, I want to grab an email, Chris, but we'll take a short break before we get into that. You can send them along anytime. Always welcome to do so. Ask@EmploymentLawyer.ca. That email is coming up here on Ask a Lawyer, right here on CP24. Coming right back.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer. Thank you so much for hanging in there. We got time to tuck into an email, so let's get that happening. Chris, shall we? Says this: boss fired me for cause for allegedly stealing equipment from a job site. Multiple coworkers have come forward to say that they saw another employee loading the equipment on a truck at the time of the theft, but my boss is ignoring them. What are my rights here?
Yeah, so anytime you hear alleged cause, just cause, you want to be obviously on alert. It's very rare, actually, that an employer will be able to substantiate a just cause dismissal. even though the allegations themselves are very serious and could result in a potential just cause termination. The fact that this individual has witnesses that could come to their aid is going to probably speak volumes. That's going to be a critical part. And if the employer is aware of witness statements, is aware of something that speaks to the contrary of what the employer itself is trying to allege, and it chooses to just dismiss those concerns, not to investigate those avenues, to sort of brush that under the rug and just go with what it initially stated, that's going to be a huge problem for the employer as well. There's going to be some inquiry for them to delve into it, especially if there's evidence that the employee has brought forward the circumstances of these witnesses being around. Just cause dismissal is known as the capital punishment of the employment law world. It basically means that if the employer can meet that threshold, you're generally not going to be entitled to any severance. You're going to get affected as far as EI is concerned. So there's a lot of knock-on effects, a big domino effect when it comes to a just cause argument. And that's why it's so hard for employers to meet that threshold because of those consequences. And unfortunately, employers have gone too far when it goes to these cause allegations. They jump the gun, and they can actually be on the hook not only to pay somebody severance for not having established just cause, but also for alleging just cause when there was no merit to do so. So it's going to come down also to the employer's argument or proof that they have to show this is our evidence. And if they have none, then the employer could be on the hook for severance and punitive damages.
Good stuff, but we are just about out of time, so we'll leave it there for now. Anytime you want to reach out to Chris and his team, the phone number always first, 1-855-821-5900. It's ask@EmploymentLawyer.ca. And again, News Talk 1010, Sundays, 1 p.m., the radio show. Join us, call in, get on air as well. And then finally, PocketEmploymentLawyer.ca is the website you can use. You'll have access to that severance calculator as well. And so good you stuck around for the half hour. We'll catch you next time right here on Ask a Lawyer on CP24.